Hello, Roger Royce, 10,000 Startups. Today, we're going to do something a little bit different than in the past. This will be a little bit more of an educational basics 101 type presentation on equity compensation in the startup context. I've been meaning to do this for quite a long time now, since it is very basic, but haven't quite gotten around to it. And I think I want to just sort of hammer through just the basics because if you try to go online and start reading about this stuff, it can get to be pretty dense and pretty confusing pretty quickly. Plus, you might miss some of the high level important things. So, equity compensation. Let's just start off. First of all, I'm going to talk mostly about in the corporation context. Now, with partnerships and limited liability companies, taxed partnerships, when we talk about equity comp, meaning that we're giving equity ownership interest in exchange for services, we'll almost always do that as what they call a profits interest. You can do that with a partnership or an LLC taxed as a partnership. And a profits interest is actually an economic ownership interest in the entity, but it only shares in the future appreciation and future income of the entity. So typically they are granted under a threshold. In other words, if the company sells for more than this threshold, then the unit participates in a share of the gain over that number. And that threshold is the fair market value as of the date of the grant. And it's really important to get that number right because the grant of a profits interest under the tax law is generally not taxable. There's a couple of exceptions that almost never apply. Generally not taxable. The grant of a capital interest, however, is taxable. Capital interest to a service provider rather is taxable. That's compensation. Well, what's the difference? Well, a capital interest means that if we liquidated the partnership today, the day we granted it, if you get something out of it, well, then you've gotten, it's like you've gotten for your services a grant of property, a little bit of the underlying property of the partnership. So on the other hand, if you were to liquidate today, you would get nothing because you're below the threshold. Well, then that's non-taxable because it is so speculative, it might never appreciate. That's the general idea. And we could spend an hour talking about that and the safe harbors and the law and the liquidation value, versus the Section 83 value. But for now, just understand that in the LLC context, that's typically how we do it. Now, you sometimes do see stock option plans in LLC, but I don't do it that way. I don't think I ever have. And the reason why is because even though that's theoretically possible, it will drive your accountant crazy. The entries they have to make when somebody exercises an option on an LLC interest. And plus you get a better tax result when you use profits interest with less hassle anyway. Okay, now turning quickly to corporations. There's really a handful of ways we would do this. We would grant stock, we call it restricted stock, to the service provider. We give them an option, we give them an RSU, a restricted stock unit, or a phantom plan unit. So let's go through these one at a time. Let me take the simplest one first, a simple grant of stock. Well, again, under the tax law, under Section 83, the Internal Revenue Code, property for services is taxable. And that means the service recipient, the person receiving the property, and stock is property, the person receiving the property has ordinary income taxed at the ordinary income, which is a higher rate than capital gains, as ordinary income equal to the value of the stock that they are granted. So if we are going to do restricted stock, it'll likely be sold at its fair market value. And this is where we get into one of the fictions that permeate startup land. And the fiction is that, gee, that stock is worth par value. It's worth very, very little, almost nothing, until something big happens, like we get an investor. And I have seen people stretch that fiction all the way beyond getting safes to right up to the point where they get their first priced round, because up till then, there's no independent third-party event that valued the company. I will tell you, I've never heard of the IRS challenging that. And I think the reason why is because let's say you're wrong and you value the property at the stock at a penny a share when it's really worth $1 a share. So you should have picked up 99 cents a share of income because you only paid a penny a share. Well, if the IRS audits you and they win, yeah, they get their tax on that 99 cents, but you get a basis step up and you're going to reduce your gain on the back end when you sell it. So there's a little bit of a character difference because your gain will be at capital gains rates or maybe even zero QSBS rates. And the income is picked up at ordinary income rates, but still, it's most likely a timing difference. Secondly, it's not something that gets reported. It's not like this is it's one of the tax shelter transactions that has to go on a special disclosure. We call that flagging the return. So it's not going to show up unless you actually are audited. So I've never seen it challenged. There will come a day, probably because of this podcast, when the IRS does realize that this is going on. We've seen that happen with stock options. For years and years, people were granting stock options way below fair market value. And the SEC found out about it first and they hated it. And they put in place their own cheap stock rules. And then the IRS found out about it and we got this code section 409A. So I think the day will come when the IRS shuts that down. But currently, people do tend to take a very liberal view of what stock is worth for purposes of selling restricted stock to service providers. Now, why do I call it restricted? You might think it's because it's got a vesting restriction, but that's not quite it. The restricted refers, I guess you could think of it that way. You could think of it referring to vesting, but I like to think of it as referring to the securities law restrictions. And in particular, the stock is not only securities law, but contractual restrictions. It's typically locked up. And it's not readily marketable because it's going to be subject to a right of first refusal in favor of the company. Call that a ROFR sometimes. That means that if you try to sell it, you have to offer it to the company first. The company then has the opportunity to buy it back at whatever your third-party sales price is. That really chills sales of stock. It's unlikely you're going to get a third party to go to the trouble to do diligence to understand the value of the stock and make an offer on it if they know they're not going to get the stocks, just that the company will buy it back. And if you're a finance company, then your investors, they'll have a secondary ROFR. So it really does stop the sale. And then there's the restriction that there's a securities law related restriction. It's under Rule 144. And Rule 144 is actually an exemption for the sale of unregistered securities in a public stock market, but it keeps individuals from doing their own little private IPO, I guess. But it is a restriction. It has to be dealt with. And I'm not going to go into it here other than to say that oftentimes companies will require an opinion from counsel that the stock is not subject to Rule 144 because it's not being sold into the public or you've met the conditions, which include a holding period, publicly available information, etc. So suffice it to say that's out there. The other restriction you will always see is a lockup. And what I mean by that, it's a requirement that you, the owner of the stock, you're not going to resell that stock within 6 months of a public offering. And the idea is that again, you won't mess up the company's IPO by going and selling your shares into the market. So those are the typical restrictions. Now, outside the startup context, you often see buy-sell agreements, which mean that if somebody is a service provider to the company, they have stock, they leave, they're obligated to offer their shares back to the company, or more typically, they die. The estate of that person is obligated to sell. The company has an option that could force the estate to sell their shares. Almost never do you see that anymore in startup companies. I used to do it early on, but almost never. And the reason why is that if somebody who has stock, so they're a pretty important person if they got stock early on, first of all. If they're not, we'd have them in an option. And if they die, that's going to be a lot of the value of the company. And we don't really have good valuation metrics until we get a little later on in the company's life. So hardly ever in the startup context just because it's not worth the trouble. And also because, and this brings me to vesting restrictions, always service providers who get stock in a startup company are going to agree to vesting restrictions. And that's the idea that they earn into their stock. And the way it's mechanically set up is that the stockholder or service provider is going to agree that the company has a repurchase right at cost, which remember is super low, less than a penny a share, maybe par value 0.001 a share. So the company has a right at cost to buy those shares back if that person leaves the employment of the company. These days, the standard documents will have that right automatically exercised unless the company says otherwise. There was a time when it was the other way around. A company had to affirmatively elect within 90 days usually. Of course, then they'd forget, and then the stock vested, and nobody intended it to vest, and your company's dead. So now it automatically is exercised unless the company decides otherwise. But that just kind of flips it around. The company then has to remember to decide otherwise if it doesn't want the shares back. But that is the less typical scenario, especially since it's so cheap. So that's the vesting restriction. And we do a whole series on vesting. You can look at all of my videos, but and I don't want to talk too much about it here other than to give you the concept and just to note that there's a tax election called an 83B election that always gets filed in a startup scenario, almost never outside the startup scenario. And what is the 83B? Everybody's heard about it. Do you know what it is and why? Well, when stock is subject to a typical vesting term, in tax language, that's known as a substantial risk of forfeiture, meaning that the stock is not treated as owned by the shareholder until that risk of forfeiture lapses, because they could lose it. So the tax law says you don't really own it yet. But now when you do vest and the risk of forfeiture lapses, well, now you do own it. That means that transfer took place when you vested. Well, guess what? The stock was worth a penny a share when I bought it. It's worth a dime a share on the first vesting date and $1 a share on the next vesting date. That means I got to pick up income at $10 a share and $1 a share. Well, that's a pretty bad result, given I have no cash here. I just have taxable income. It's got to go on my tax return. So the 83B election allows you to close the compensation element and treat the transaction as closed and as though you own the stock on day one, on the date of transfer, even though there exists this vesting restriction or substantial risk of forfeiture. Like I say, in startup land, we always do that because we value the stock so low and there's a minimal tax impact. With mature companies, public companies, you almost never do that because you don't want to pay a lot of tax today. You'd rather wait and pay a little tax, pay a lot of tax later, I guess. So those are usually the dynamics. That E3B has to be filed in writing, has to be signed, and it has to be filed within 30 days of the transfer. There is 0 grace period. If you file it 31 days after, it is totally ineffective. And that is the obligation of the employee stockholder. And again, these days, the documents will go way out of their way and beat you over the head with the language that says, we're not going to file this for you. It's your problem. And the reason why is because people miss this all the time and just regularly. Now, I've got a hack for that if it happens, but that's not something I'm going to get into here. Okay, that's restricted stock. When would we use it? My rule of thumb, founders, people who want to close the compensation element, want to start their capital gains holding period running. Remember, that's 1 year, or their qualified small business stock holding period running. Remember, that's 5 years. We are willing to pay a teeny amount of ordinary income, tax on ordinary income now to get the 20% capital gains rate or the 0% QSBS rate later. So, but those are bigger shareholders because they are going to be shareholders. They got information rights, they got voting rights, they can cause problems in the company, they're on your cap table, etc. Well, suppose we have smaller shareholders, and we didn't even talk about the securities law requirement. The other thing is that it's a transfer of shares to a service provider is a sale of securities. So it's got to clear both the federal and state securities rules. Now, the federal rule is usually, oddly enough, is usually the easy one here because we've got a rule called Rule 701, which applies to transfers to individual service providers under a plan. So we're going to talk more about that in a minute, but it's a huge rule. It's a huge exemption, and it's pretty easy to comply with. The state rule, however, that depends on the state. And here in California, where I practice, the stockholder has to be sophisticated. And the word sophisticated doesn't mean what you think it means. It means they have to really be in a position to take care of their own interests because they understand the company, have a pre-existing relationship, etc. We almost always meet that standard, but the key is almost. And I have had it happen in my career where I just said, look, there's just no way that we can justify this sale of stock. So rather than take any chances on that, and rather than having to screw around with hoping that we comply with a non-Rule 701 exemption at the federal level, which is Reg D, meaning they have to be accredited, what we'll do is we'll grant stock options because we can do all of that under what we call Rule 701. So let me take that apart for you a little bit because this is really what gets done in Silicon Valley mostly. And keep in mind, this valley was built on equity compensation, and most of that has been through stock options. And in my career, I worked with hundreds of plans, maybe thousands, definitely thousands of option grants. And I think I've kind of seen it all when it comes to startup company stock option and equity comp. So let me hit the high points. The stock option is not stock. It is a right to buy stock at a certain price. And that certain price is the value as of the date of grant of that right. So your stock's worth a penny a share today. You get an option to buy shares. It means you can buy a certain number of shares at a penny a share during the term of the option. Stock goes up to $1 a share a year from now, you get to buy at a penny a share. Company gets sold a year from now, you'll typically just cash out or they'll get substituted, but you'll get the value of that option somehow. Or maybe you'll exercise and sell, or maybe it'll get assumed by the acquirer. In any event, you get the value of that option. The beauty of the option is optionality, meaning that you get the upside, but you have no downside risk. Like unlike investors who have to pay for their stock, you just have a right to the upside, the appreciation in that stock, and it doesn't cost you a dime. You just have to continue to work for the company. Now, that's the beauty of it. It's a great deal. It's all upside, no downside, except with most options, what we call non-statutory options. When you do cash out, when you exercise, when you cash out, you're going to get taxed at ordinary income rates on a difference between the value of the stock and your exercise price, which remember was the cost that you got in at. And that's a high rate. It's ordinary income rates. It's not capital gains rates. On the other hand, if you exercise your option, hold it for a year, then sell, you get capital gains rates on the appreciation or on the gain on sale. And that means anything over what you paid for it. And if you can hold it for 5 years, you might get QSBS treatment, which is a 100% exemption from federal tax, up to the greater $10 million or 10 times basis. And there's a bunch of requirements. You should go see some. In fact, we just did a webinar last week on QSBS requirements. We've got several of them since it's such a big deal. It is the number one thing that's going to drive you to exercise an option and give up this optionality where you have no downside risk. Now, before I talk about the differences, I know what you're thinking. You're going to say, well, I have an idea. What if I get the company to loan me the money to buy the stock at this price? In fact, why do I need an option plan at all? Just sell me restricted stock. Just loan me the money. In other words, I'm going to sign a promissory note to you, the company. And that way, I don't come out of pocket and I get this upside risk. And that works great. You start your holding period, you hold for a year or 5 years, you get your upside benefit. It works great until it doesn't. And when it doesn't, is if the company goes under, it goes bankrupt, the stock value goes down, and you have a bankruptcy trustee or the company or investors or somebody, creditors, coming after you to pay that note. And I have seen that happen. And then when it happens, it's pretty ugly. So just be aware, there's the thing that makes it work is the risk, the entrepreneurial risk in that note. The other thing is that the note has to be a real note. And this is more art than science, but in startup land, we typically will feel comfortable if there's a certain amount of recourse, like more than 50% recourse, meaning that you personally can be held liable. In other words, they can take the stock back if you default on the note, but it could hold you personally liable for more than 50%. Standards vary in other types of securities. I used to do real estate tax, and there, if you had 20% equity, you felt good about it. In startups, we say more than 50%, we feel okay about it. But again, that's more art than science, and not something I can say has been tested in court. Alrighty, getting back to the options, two kinds of options. NSOs, non-statutory or non-qualified options, and ISOs, incentive stock options. So the NSO is what I've just been describing. No tax on grant of the option. There is a tax when you exercise the option or get cashed out. And exercise means that you just buy the stock subject to the option. And the amount of income that gets taxed is the difference between the value of the stock and what you pay for it. All right, kind of what you'd expect. The general rule in compensation when you have property for services. So along comes the ISO. And the ISO sounds like a great idea. It's where Congress said, you know, let's give these employees a little better deal. And by the way, it is only employees, not directors, not consultants, not advisors. Only employees can have an ISO. And no grant, no tax on grant of the ISO, just like an NSO. You're just giving them this right to buy. No tax on exercise of the ISO. Oh, well, that's good. And we start our capital gains holding period running, and there's no tax until we sell the ISO stock, and then it's at capital gains, or if you're lucky, QSBS 0 rate or capital gains 20% rate, provided you meet a 1 year from exercise holding period and a 2 year from grant holding period. Sounds too good to be true. Our ISOs are awesome. Well, there's a couple little wrinkles. Number one, it's pretty restrictive. The ISO expires 10 years from grant date. It has to be exercised within 3 months of termination of employment in order to be an ISO. If it's not, it doesn't go away. It just becomes something. It's not an ISO, an NSO. There's, as I said, only employees. There's also, this is odd, $100,000 a year per year limit. So you can only get $100,000 per year of ISO stock. Anything above that is not going to be an ISO. It will be an NSO. Well, it's sort of a drop in the bucket out here in Silicon Valley. And here's one that, another weird rule. If you're a 10% stockholder, owner of the company, the ISO exercise price has to be 110% of fair market value. So you can see how easy it is to miss that one. So there's a lot of little technical rules, but I'm saving the biggest one for last, and that is AMT. And every 4-year-old child in Silicon Valley knows what AMT is. And they know that on exercise of an ISO, you're going to have an AMT consequence. Well, what is AMT? It's a lot of things, but for my purpose, it's alternative minimum tax. And it's such a complicated formula. I don't want to go through it in great detail. I just want to say the idea is that, again, you know, the Congress is looking at us out here in Silicon Valley, looking at this sweet deal we've got with our equity compensation. And they're saying, look at these guys at these ISOs, they exercise, they don't pay any tax, and they get out at capital gains rates, maybe even 0 rates. We got to stick them with something. AMT, alternative minimum tax, it's like a parallel tax system that runs alongside the normal tax system. So for people who can hire people like me to tell them how not to pay tax, you know, get their tax rate down to 0, we're going to stick you with an alternative tax. And this ISO gain, this spread that avoids tax, is going to go into AMT. Now, there are exemption amounts. This is 2024. The exemption amount, if you're single, is $85,700. If you're married filing joint, it's $133,300. But the exemption amount phases out. This is 2024. If you're single, it phases out at just over $600,000. If you're married, filing joint, phases out just over $1.2 million. So you can exercise and have preferences. That's what they call this. They call these preferences. And it's not just this. There's a bunch of other preferences. You got to add them all together when you do the calculation. But you can have preferences up to the exemption amount and not pay AMT. And then everything over that, you pay AMT on. And there's two rates for AMT, 26% and 28%. Pretty high, depending on how much alternative minimum taxable income you have. Now, I want to go back and mention, suppose you're granted the option and the option vests over time, which is really very, very common. I mean, that's how we always do it. Remember what I said about that 83B election. Well, are we going to have to file an 83B election? And the answer is a very unequivocal no. You would not. It wouldn't be appropriate. Why? Because the grant of an option is not a grant of property for Section 83 purposes. There is an exception in 83 for this. However, once you exercise the option and you buy the stock, now you do have a transfer of property. And if the option allows for what we call early exercise, meaning you can exercise for non-vested shares, well, now you do have to file an 83B election. Not all option agreements do that. Some plans, most of my plans, I would say, will only allow an exercise for vested shares just to avoid the complication. So if you want to kind of follow this down the logical path, say, oh, okay, got it. We'll exercise, we'll file the 83B, we'll close the compensation element. What if I exercise an unvested ISO? Now, that's sort of a rare thing. I mean, sort of rare. I mean, we see it. I try to talk people out of it. My advice is if you're going to do early exercise, that means you can exercise for unvested shares for an ISO, just convert it to an NSO and save yourself the brain damage that I'm about to describe to you. So what you'd want to do is a protective 83B for AMT purposes. And well, why do we have to do that? Well, because what I said happens for an income tax purpose with regard to using up AMT preference and exemption amount, rather, that happens. In other words, what I said happens for NSOs for as the stock price goes up, the ordinary income goes up on vesting dates. That happens for AMT purposes as well, if you get my drift. So you want to close that so you don't have AMT every year that you have vesting on the option. And there's another complication. Okay, what happens if I exercise my ISO and then, you know what, I sell my ISO stock before I've held it for a year or sold it before I've held it for 2 years from issuance of the option? Well, remember, the rule is on ISO, it's not an ISO. You don't get these ISO benefits unless you meet those 2 holding periods. We call that a disqualifying disposition. And when that happens, the recipient has to include in income, ordinary income, for income tax purposes. The company, by the way, the company doesn't get dinged for FICA FUTA, if you want to talk about getting in the weeds. But anyway, the recipient has ordinary income as though it were an NSO. So this is starting to get really complicated really fast, and we're starting to have to get our crystal ball out. So I have a lot of option plans where I describe this to people, and for 30 years I've been hearing them say, you know what, forget about this ISO stuff. We're just NSOs all the way. They can pay a little tax. They ought to be happy they're paying tax. It means they've got gain, and we're just going to follow the KISS principle here. So just keep that in mind. That's probably what I see most often. Okay, let me just, because I wanted to make this high level and as a summary, the 2 other things I want to mention are RSUs and phantom plans. RSUs are restricted stock units, and the nature of an RSU is different than restricted stock, which is granted today, usually subject to a vesting restriction. A restricted stock unit has a vesting restriction, and it's a right to stock when you hit the vesting dates. Boom, 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 boom. Okay. On that date, you now have ordinary income equal to the value of stock that you're given. So this is something you hear a lot about, but in startup land, almost never used. And that's why, because now you've got this non-liquid, non-marketable stock that you can't convert to cash, but you've got a tax bill. Now, if you're an employee of a public company, well, that's a good deal because you can sell the stock, pay the tax. Startup company, you can't do that, right? Maybe you can do a secondary, but good luck. So almost never would I see an RSU in the startup. And if someone wants to do it, I'll talk them out of it. And then finally, phantom plans. So the idea, I've been doing phantom plans for 40 years. I'm not, well, for as long as I've been practicing, I'm not making that up. And the reason why is because we avoid all of these complicated stock option rules and we avoid all of these stock rules. And in fact, a well-drafted phantom plan is going to disclaim any responsibility for almost anything. It's going to say, look, we're not stock, we're not a retirement plan under ERISA, we're not a severance payment subject to any of the labor law rules. We're not deferred compensation under 409A that I probably mentioned earlier. We're not anything. We're just a discretionary bonus. I have seen every one of those assumptions challenged, by the way, just so you know. But plans are typically set up, to try to avoid those rules and say, look, it's just a discretionary bonus. And a typical setup, by the way, if California even has a regulation on it, it's a 260.105.5 that says a phantom plan unit is not a security, and then it defines phantom unit. So yeah, go figure. So California, home of equity comp, even our regulators recognize the value in these. And anyway, so what it is, it's like we're going to give you a unit, and this unit mimics stock. And we'll also, most of my clients, they hate the name phantom plan. It sounds so scary. So we'll call it incentive plan, performance plan, bonus plan. If it's connection with an M&A, a carve out plan. I had one I called the Tahiti plan one time because you can guess what they were planning on doing with the proceeds from it. So anyway, so you've got your Tahiti plan. And what it says, we're going to give you a unit, employee or consultant or service provider, whoever you are. And that unit is going to pay you a share of, it could be dividends, just like a share of stock. You get a dollar per unit of dividend for every dollar per share of stock the stockholders get. And or it will pay you some amount on change of control. And the way I like to do it, I used to do it where we'd carve out 10 or 20% of the exit proceeds and allocate all that to the phantom unit holders. Got to be careful about that because, that means if you have one unit holder or 100, they're getting X carve out. So I don't do it that way anymore. The way I draft it these days is, look, you get, each unit equals a share of common, whatever the common get, you, the unit holder, get, then they just act in lockstep. It's really a derivative of the common. And in fact, it works just like an option because even though I've given you all these rules for exercise and holding and, this and that, as a practical matter, people get into options because they don't want to spend money on buying stock and they just sit and hold them. And if they leave employment, they don't exercise very often. I mean, it's not never, but more often than they will more often not exercise, just let the option expire after 30 or 90 days, whatever the option document says. Or because it's a vehicle to incentivize and retain employees, they'll stick around until an exit, and then they will cash out in the exit. Well, a phantom plan can do all that without all of this paperwork. We got to grant the option, et cetera. Got to have a stock option plan. So phantom plans are becoming more and more popular now, ever since 409A was enacted, which was in like 2005. And 409A requires for all practical purposes, it requires for startups a valuation at the time of grant. So we know what the value of the stock is when the option is granted. Well, you don't need that with a phantom plan. So, and we don't have a tax impact on grant of the units. The downside, of course, is that it's all ordinary income. The other thing is that most of these plans are drafted for regulatory tax reasons to comply with what we call the short-term deferral exception of 409A, meaning, to make a long story short, that the employee has to be there when the company gets sold in order to participate in the proceeds of a sale, which is what you want anyway. This is an incentive plan. It's a retention plan to keep employees around. So there you have it. That pretty much is the universe. I didn't spend a lot of time on 409A because we've done a whole session on that. I didn't spend a lot of time on some of these other issues like QSBS because we've done a session on that. But that is sort of the high level of the most common types of equity compensation and where you might see them in your company. So this is Roger Royce, 10,000 Startups. Thanks for listening.